Hey everybody, John Skiba here. Did you know that 95% of people who are sued by debt collectors don't do anything and they end up with a default judgment? Well, in this video, I'm going to talk about a unique strategy of doing nothing and when that may be appropriate if you've been sued by a debt collector. But first, if this is your first time here to my YouTube channel, go ahead and click subscribe. That way you'll get notified each and every week when I put out new videos to help you deal with your serious debt problem. All right, let's talk about debt collection lawsuits, responding to them, and some different strategies. I'm going to give you something that's a little unique and may sound a little crazy from the outset, but hear me out on this one. As I said in the intro, 95% of people who get sued by debt collectors, whether it be an original creditor, credit card companies, junk debt buyers, 95% do not file a response to the lawsuit. And because of that, a default judgment is typically entered by the court. You end up owing the full amount, and then the collector goes about trying to collect on that judgment. Now, it's important to understand the reason why a debt collector or a junk debt buyer, the reason why they want to get a judgment against you is because that gives them a lot more power. Once they're armed with the judgment, they can come after you, they can try to garnish your wages, they can lien property, they can take property in some cases, they can go after money in your bank account. So the strategy that I'm going to give you may seem a little counterintuitive. And that is, in certain circumstances, it's possible for you to do nothing as a strategy. Hear me out. Here's when it's possible. And it's important that you understand that there's a very kind of limited window when it's appropriate to just do nothing, because it often flies in the face of everything that I talk about on this YouTube channel, where you have to take action. But in certain circumstances, it may be okay to just do nothing, to not respond to it, to allow them to get a judgment against you. And the circumstances in which that may be an appropriate strategy is when you are essentially what we call in my industry judgment proof, where even if they get a judgment against you, they're not going to be able to take anything from you. Usually that's because of one of two reasons. The property that you have is exempt, or that you don't have significant property for them to attach. So for instance, let's say that your sole source of income is Social Security, whether it's disability or retirement. You don't receive any other income other than Social Security. Well, Social Security income is exempt under federal and pretty much every state law out there. And so if the debt collector gets a judgment against you and your only income is Social Security, they are not going to be able to garnish those funds. They can't garnish Social Security and take those funds from you. And that's true even if it's in a bank account. They can't take those funds. So that would be an instance where them having a judgment does not actually help them a whole lot as far as taking funds out of your bank account or taking it out of your paycheck. It's also the case if you don't have significant assets. Let's say you don't own any real estate, if you don't own a vehicle, or if there's just, you just have household items, there's likely not a whole lot they can do to actually take any of that property from you. Now, in saying this, it's important to understand and for you to learn what the exemptions are in your state. Every state has a set of laws that exempt out certain property from your creditors. They do this because the law acknowledges there should be at least some baseline ability to be able to live. That they can't garnish your full paycheck, they can't take your couch out of your house kind of thing, or you take your bed. There's certain exemptions that each state has that protects certain property. And usually there are dollar amounts tied to that. So for example, here in Arizona, where I live and where I practice law, you're entitled to a $6,000 exemption in a vehicle. So that's $6,000 of equity in a vehicle you could have. And if you're married, you and your spouse each get a $6,000 exemption. So if I had been sued and they had a judgment against me, if my vehicle was worth less than $6,000, then there's not really anything to do. They can't take my vehicle and try to sell it because it's exempt. This is also true if you own a home. Most states have a homestead exemption that protects a certain amount of equity in your home. Again, in a state like Arizona where I live, it's $150,000 of equity. If you don't have more than $150,000 of equity in your home and you live in the state of Arizona, there's not a whole lot they can do with the judgment. So it's important that you learn what your exemptions are. It's really easy to find this out. You can just put, if you live in Florida, you can put Florida exemptions or Arizona exemptions. Just Google that. You'll find a ton of articles with information about those specific statutes in your particular state. Now, one little word of caution here. If you elect to do nothing and they get a judgment against you, Even if all of your assets are either exempt under federal or state law, or if you don't have a lot of assets, so there's not really much for them to take, that doesn't mean that they won't still try. That doesn't mean that if you keep all of your Social Security in a checking account, that all of a sudden you're going to get hit with a bank levy. They may file the bank levy, but you will have the defense of being able to raise and say, hey, these are exempt funds, they're going to have to release those. So really what I'm trying to say there is, even if you choose to do nothing, even though they can't take anything from you, the judgment is still there. That doesn't mean that you don't owe the money, and it doesn't mean that you're not going to have to deal with collections. And so often when I meet with clients, that's what they're kind of weighing is, they won't be able to take anything from me, but am I okay with kind of harassment that I'm going to have to deal with? And civil judgments can be good for a long time. In Arizona, they're good for 10 years, and then they can be renewed every 10 years. And so one, if you think that you can't handle that kind of harassment or just uncertainty, then you may want to still file an answer with the court and contest it head on. Or if you think your situation may change, like I said, like in Arizona, that judgment could be good for 20, 30 years. Then you may want to look at just dealing with it right now rather than letting them get a judgment, knowing that they can't do anything at this very moment. So I hope that helps. The do nothing strategy, there's a very limited number of people whose situation justifies that type of approach, but I wanted to throw it out there because I had some comments in the channel here of people saying, I don't really have anything. Do I really need to contest this? In certain circumstances, you may not. You probably want to meet with an attorney in your area and just confirm what the exemptions are and make sure that you're fully protected. Thanks for watching today.